want to make sure.
All right, Mr. McNamara, are you able to hear me okay?
Yes, sir.
Yes, sir. Okay, we're on the record in People versus Clifford McNamara, case number 244932. If I can have counsel put your appearances on.
Thomas
Seeger appearing with on behalf of Mr. McNamara.
Okay, this is set as a final status conference date and plea cutoff. We have trial set to begin on February 19th. Obviously, we've had some motion practice recently in this file, but Mr. Seeger, have you talked to your client about the plea cutoff part of this?
I have, Your Honor. Your Honor, I did. However, it's my understanding that the people are in the process of. I'll let the prosecuting attorney put his position on the record, and I can.
Your Honor, we've been attempting to get a hold of Lauren McNamara for some time now, particularly since the court's most recent ruling. We've called her multiple times a day, every day since January 27th. We've been unable to get a hold of her. That, in combination with the court's ruling regarding the issues with her credibility, lead me to believe that our likelihood of success at trial is minimal. For those reasons, Your Honor, I will be filing a nollie in this matter. I would like to continue to get a hold of the victim, or at least attempt to do so, to notify her ahead of Mr. McNamara's release, just so that she can make any plans or arrangements she needs to make. But one way or another, Your Honor, the case will be dismissed by the end of the week.
Okay, Mr. Seeger.
No objections, sir.
Okay. All right, Mr. McNamara, were you able to hear that?
Yes, sir. Yes, Your Honor. Yes, sir.
Do you have any questions at all?
No, sir. No, sir.
Okay. So should we adjourn the trial date at this point, Mr. Ziegler?
Your Honor, I have no intention of proceeding with that trial date one way or the other, so I leave that to the court's discretion. It's fully my intention to file the nollie by the end of the week.
I guess, Mr. Seeger, unless there's an objection for you, I'm going to leave the trial date on at this point. I think for no other reason, your client's entitled to have the prosecutor go forward with trial on that date. If he doesn't, for some reason, file a nollie between now and then, what's your view on that?
Your Honor, I take Mr. Ziegler's word, Your Honor, that he's going to dismiss the matter, and we have had quite extensive discussions prior to the motion, following the motions, and so to my understanding, and again, I'm not questioning Mr. Ziegler in any way, to the extent that he is representing to the court that he is going to dismiss the case in its entirety, irrespective of whatever it is that the complaining witness might say, even assuming arguendo that he's able to contact the complaining witness. I have no reason to keep the matter on the docket, but if the court wishes to keep it that way, I have no objection.
Okay, and certainly I'm not questioning Mr. Ziegler's representations here in court, but I think to protect your client's rights, we should leave the trial date on until that nollie is presented to the court for signing. So I'm just going to have the notes reflect that the trial dates to remain on. Parties anticipate file being dismissed prior to the trial date. Anything further on this file?
No, sir.
Okay. All right, Mr. McNamara, that's all for today, and the court's going to disconnect at this time. Okay.
Thank you, Your Honor.
And Mr. Seeger, is this Mr. Patrick?
It is, Your Honor.
Okay, Mr. Patrick, could you come up to the podium there, please? We'll go on the record in People versus Darnell Patrick. This is file number 244981. The record should reflect Mr. Patrick's present here in the courtroom today. If I could have counsel put your Ms. Miller, are you able to hear me?
Yes,
Okay. Okay, we'll go on the record in People versus Jennifer Hiller. This is file number 244956 and 244976. The record should reflect that Ms. Hiller is appearing today by video from Wexford County Jail. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger appearing with and on behalf of Ms. Hiller.
Okay, this is set for status conference in both files today. Mr. Seeger, can you update me where we're at?
Your Honor, it's my understanding that Ms. Hiller has been offered an opportunity to plead to file 244976. In that file, she would plead with no habitual offender notice. Additionally, Your Honor, it's my understanding that in lieu of her plea, file number 4956 would be dismissed. Additionally, Your Honor, in speaking with the prosecuting attorney and in speaking with probation and parole, after having gone through the guidelines, it appears as though Ms. Hiller is in a straddle cell. I do understand that the prosecuting attorney believes that prison would be appropriate. However, in speaking with probation and parole, it's my understanding that they will recommend a county year. At which point I did express to my client that it's not specifically up to me to determine what the ultimate sentence would be, but that it is possible that you could receive a county time sanction. And additionally, that is the recommendation of the Department of Corrections.
Okay, all right, Mr. Ziegler.
That's all accurate, Your Honor.
Okay, Ms. Hiller, were you able to hear all of that?
yes, I was.
Okay, and did you want to move forward with that plea agreement today?
Yes, Your Honor.
Okay, you understand that although the probation department is going to be recommending a county sanction for you, that's just something that they're making a recommendation for. And sitting here today, I without having gone through your pre-sentence report and seen the guidelines myself, I'm not making any decisions about what an appropriate sentence is. So I may or may not go with that recommendation. Do you understand that?
Yes, I do.
Okay. Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Ms. Hiller, you understand that you're going to be pleading guilty to one count of possession of methamphetamine with no habitual enhancement. That's a felony that carries with it a maximum of up to 10 years and or a $15,000 fine. Do you understand that?
Yes, I do.
And then in exchange for you entering that plea today, the habitual enhancement on that case is going to be dismissed. And then your charges in the other file, which involve a embezzlement charge, that's also going to be dismissed. Is that your understanding of the agreement?
Yes, it is.
Are you currently on any kind of probation or parole?
I am currently on parole out of Kalkaska County.
You're on parole, you said?
Yes,
Okay, so you understand that based on your parole status, that any sentence in this case would have to run consecutive, in other words, back to back instead of at the same time with any parole violation.
yes, I do.
And you also understand that you will not be entitled to any jail credit because of your parole status.
Yes, I am.
With all of those things that we've discussed here in mind, what is your plea to the charge of possession of methamphetamine today?
Guilty.
Right now you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, I am.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we've said here on the record today?
no,
Is it your own free choice to enter this plea?
yes, it is.
Are you pleading guilty because you are guilty of this charge?
Yes,
This charge relates to an event that happened back on July 31st of 2024. Is that the correct date?
yes, it is.
On that date, were you present here in Kalkaska County?
Yes, I was.
While you were here in Kalkaska County on that day, did you have possession of some methamphetamine?
Yes, I did.
Did you know that that's what that substance was?
Yes, I did.
Did you have any legal right to have any amount of it at that time?
No, I did not.
All right, thank you. Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Ms. Hiller, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. This matter will be set for a sentencing hearing. You'll be notified of the date and time of that hearing. In the meantime, somebody from the probation department will be in touch with you for a pre-sentence report. Mr. Ziegler, anything further on these cases today?
Okay, Your Honor.
Mr. Seeger?
No, no.
Ms. Hiller, do you have any questions at all?
No, I did not. Thank you, Your Honor.
Okay, thank you. That's all for today, and the court's going to disconnect at this time. Okay, next hearing set for 9:30 with Mr. DeGrot. That the one section?
She is, or at least to my understanding, she's the department. Your Honor, additionally, because we tried to call her previously, because we were unable to get her here. I don't know how to state this aptly, but you had considered through no fault of her own, we might give her additional credit.
Oh, yeah, yes. Okay, I don't see them connecting yet, so we'll take a recess until 9:30. Ma'am, can you tell me your name, please?
Cassandra DeGrot.
And you needed to speak with her, Mr.
If I could, Your Honor, if I could just log into Zoom.
Ms. DeGrot, I'm gonna put you into a breakout room with your attorney so that you can have a confidential discussion with him, okay?
Okay, thank you.
This might be a minute here to make that connection.
Mr. Grote, can you hear me?
Yeah, hey, how are you?
Okay.
Hold on one second, Mr. Seeger. Okay, the room should be opening now.
You're all excited.
Okay, I'll set.
Mr. Chapman, who's up in a little bit, had emailed me that he tested positive for COVID at an in-home test. I directed him to keep going here, but I think he's in the car. Is it okay if he appears by Zoom?
Yes. All right, Ms. DeGrot, are you able to hear me okay?
Yes, Your Honor.
We'll go on the record now in People versus Cassandra DeGrot, case number 244913. The record should reflect Ms. DeGrot's appearing today by video from Michigan Department of Corrections. If I can have counsel put their appearances on.
Ryan Ziegler on behalf of People, Your Honor.
Thomas Seeger appearing with him on behalf of Mr. DeGrot.
Thank you. This is the date and time set for a sentencing hearing in this matter. Mr. Seeger, have you had a chance to go through the pre-sentence report with Ms. DeGrot?
I have, Your Honor.
Okay. And Ms. DeGrot, did you have an adequate opportunity to go through that report with Mr. Seeger and talk to him about it?
Yes, Your Honor, I have.
Okay. Mr. Seeger, are there any additions, deletions, or corrections that need to be made to that report?
Your Honor, and I don't know if it's an addition, correction, or deletion, and I just did have a brief conversation with the prosecuting attorney. I think to a certain extent, it's correct that because she's under sentence, she doesn't receive credit for the time that she served up until the date of sentencing. However, I would note that she was originally supposed to be sentenced on 1/7/2025, and through no fault of her own, she was unable to appear. So whether or not the court gives her credit relating back to 1/7, or maybe there's some kind of fictive credit one way or another, or the court takes that into consideration in terms of just general sentencing. I'm not sure how the court wishes to address it, but she would have appeared on 1/7, but for her inability to do so.
Okay. And it's, Mr. Ziegler, do you take any position on that?
Your Honor, I think legally she was sentenced in Grand Traverse County on December 12th. Because she's under sentence, she's not entitled to any legal credit. And whether the court chooses to give her some form of fictive credit in taking that into account in terms of the sentence, I leave that to the court's discretion. I don't think any changes to the PSI need to be made.
Right. Okay. So, I mean, I agree from a statutory standpoint. I don't think she's entitled to the credit. I do think in the interest of justice, Ms. DeGrot would have appeared. There's no indication that she engaged in any actions to delay her appearance here today, and that it was solely because of the Department of Corrections. She was properly writted, counsel both did what they were supposed to do. So from my viewpoint, everyone other than Department of Corrections did their due diligence to have Ms. DeGrot present for sentencing as previously scheduled. So I think, again, in the interest of justice and fairness, she should be entitled to credit between January 7th and today, which the clerk has calculated at 29 days. So 112 days was the credit she's entitled to, plus the extra 29, 141 days. So the court intends to grant 141 days of credit. So I am gonna ask that the PSI be amended to reflect the additional credit and that it's discretion of the court. Any other corrections, Mr. Seeger?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, I don't want to belabor the point here. There's simply nothing to do with Ms. DeGrot other than sentence her to MDOC. This is her 32nd conviction, give or take. She has warrants for drunk driving out to 2 other states. She's currently serving a 20-month sentence for OWI 3rd out of Grand Traverse County. By my count, this is her 6th sentencing for a drunk driving offense, which excludes her 2 open out-of-state warrants, and it also excludes another OWI that she had pled down to a reckless driving. So factually speaking, this would be her 8th OWI, and the one in Grand Traverse, which she's already been sentenced on, would have been her 9th OWI. She has convictions for drug offenses, thefts, breaking and entering, absconding, child endangerment, identity theft, prescription fraud, and domestic violence, along with numerous traffic offenses. She has a lengthy history of absconding, failing to appear, violating probation. She's failed to appear multiple times in this case. She's not been compliant on bond in this case. She's still a parolee out of Tennessee for a larceny, $10,000 to $60,000 there. Her BAC in this case was a 0.327, which is extremely high. And to top it all off, Your Honor, her description of the offense in the PSI totally minimizes her conduct that day. There's simply no redeeming factors about this case. There's no mitigating circumstances. We're well past the point of rehabilitation being a reasonable goal. There's simply nothing to do but sentence her to the maximum in this case, Your Honor. And just hope we delay as long as possible her 10th OWI. So for those reasons, Your Honor, the guidelines are 12 to 24. I've rarely seen a case where the top end of the guidelines is so deserving. I would ask the court to sentence the defendant to 24 months, subject to that 141 days credit.
All right, thank you, Mr. Seeger.
Your Honor, it's difficult to wholly disagree with Mr. Ziegler as much as she does have a substantial criminal history. Clearly, she has a substance abuse problem that she's not been able to address, and I think she continues to struggle with it. Hopefully, the time that she's serving under the Department of Corrections allows her to maybe reevaluate what she needs to do going forward. And she had expressed as much when I was speaking to her. I guess to the extent that the court is going to impose a sentence, I would ask the court to give her a similar sentence to that of Grand Traverse County, and maybe less, not because it's specifically deserved in either which way, Your Honor, but primarily because she's going to be Grand Traverse County, not unless her sentence is greater. Clearly, Your Honor, once she's paroled, she'll be supervised one way or another. She did indicate that during the course of her incarceration, she's hopeful that she'll be able to that they have available to her there, that they may not be able to afford her in other situations. And she recognizes that her actions were wrongful, that it places other people in danger, and that someone like conduct is not really a good life plan. So hopefully you have a lesson for her. Drinking problems, it's unfortunate, and clearly getting behind the wheel of a car after having consumed alcohol is not a very good decision. She accepts responsibility for what she did, and she's hopeful that the court will give her a similar life sentence.
Thank you. Mr. DeGrot, anything that you wanted to say today?
I do apologize, Your Honor. I think that, it took me 43 years to kind of realize, but I think that all my drinking, my substance abuse, and all my criminal past is more of mental health. And I kind of realize that now, so I'm getting the help that I need mental health wise, and I feel like that and I have a plan to go to a recovery home for 2 years upon my release called Healing Through Hope. And she's gonna I guess kind of touch base with my trauma and stuff like that. So what I'm doing here is I'm gonna take healing through trauma and substance abuse. And I hope that with those together, I can more focus on my mental health. And as long as I can stay stable on that, I won't drink. And I didn't do that in the past. So hopefully that my time here, I can just do that differently and kind of stabilize on medications for mental health. And that'll keep me on the right track, and then surround myself by people in the recovery home instead of people that I would normally associate with, and associate myself around people that are positive and that don't drink, and maybe do that differently, because I never did that in the past. And now I realize that that's what I need to do. I didn't really realize that before. I would always get out of jail and just depend on my own mental health and get depressed and all that, and then just self-medicate. And I realize now I can't do that. So I can just try. So I do apologize to the courts, and I know that I could have harmed a lot of people other than myself. And thank God that I'm sitting here, because if it would have happened another way, I could be looking at a life sentence, or, and have to deal with a tragedy from another family. And I'm just grateful that I did it.
All right, thank you. Mr. DeGrot, I did read through the pre-sentence report. There was additional information in there also about your background from a prior report that was done. And taking all that into account, along with what you've had to say here on the record today, I mean, I think you're right. People that have a problem with alcohol or other substances, there's usually a underlying factor there that contributes to that and makes it difficult for them to rehabilitate until they address those underlying issues. So I think that's a positive for you going forward. The negatives, of course, are your past history and the number of times that you've engaged in this conduct and done exactly what you said, which is put other people, innocent people in the community, in danger through your behavior. And so the court does have an interest in punishing that. Of course, your past history results in guidelines that do call for prison time, and I think that's absolutely warranted, given your conduct in this case and in prior cases in your prior history, which Mr. Ziegler, I think, very adequately laid out, and the court would also rely on the statements that Mr. Ziegler made in terms of your past history and justifying prison here. So the court does find that a sentence at the top of the guidelines is warranted. The court is going to sentence you to 24 months to 5 years in the Michigan Department of Corrections. As we've indicated, you do have 141 days of credit. That sentence to run concurrent to the sentence in Grand Traverse County, file number 2415029. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence. If you haven't already received it, the court is going to provide you with some documents that explain to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with any appeal. Mr. Ziegler, is there anything else that we need to address for the record today?
No.
Mr. Seeger?
No.
Okay. Mr. DeGrot, that's all for today, and good luck to you going forward. The court's going to disconnect at this time.
Okay, thank you, Your Honor.
Ma'am, are you Ann Weaver?
Yes.
Okay. Travis present. We'll go on the record then in People versus Ann Weaver, case number 244983. The record should reflect that Ms. Weaver's appearing today by video from Wexford County Jail. I can have counsel for your appearance.
Ryan Ziegler, on behalf of the people, Your Honor.
Yeah, Travis, on behalf of Mrs. Weaver.
Mr. Travis, can you tell me the status of this file today?
Yes, Your Honor. We had adjourned last time in basically pursuit of a resolution. We've mapped out that resolution. The issue is it involves paying a large amount of restitution. Ms. Weaver and her husband have been pursuing getting a home loan. And we asked for time last time. I gave yesterday some documentation to Mr. Ziegler demonstrating that process. They've gotten all the inspections and everything done. And speaking to Cameron, Ms. Weaver's husband, and he's speaking with the lenders, it's probably going to be 2-3 weeks, and they should have the money. So we would ask for another 30 days with the belief that we will have a resolution when we come back, because the money does look like it's en route, if you will.
Okay, Mr. Ziegler.
Your Honor, this case has been going on for a little while, and I've heard a lot of promises that this money is on its way. I finally do have some documentation to that effect. So that makes me much more confident that we may be able to resolve this case with some restitution up front and maybe a reduced charge. So for those reasons, Your Honor, I would support the defense request for.
All right, Ms. Weaver, were you able to hear all of that?
Yes.
And is that how you would like to proceed as well?
Yes.
Okay. So the court will set this for a plea hearing in 30 days with the anticipation that we'll be ready to move forward with the resolution at that time. Mr. Travis, anything else that we need to address on this case today?
Just a comment to Ms. Weaver. Ms. Weaver, with your most recent letter, I have discussed that with Mr. Ziegler, and he's checking into that.
All right.
Ms. Weaver, do you have any questions?
No, I would like to be able to get a bond. I don't want to pay a bond again because it's not going to go towards this matter. I think that if any money is paid towards a bond, it should go towards a matter. And, you know, I have said almost 4 months. I would appreciate to be able to get some type of bond out, especially now that I have proof that the loan is coming through.
Okay, well, that's something that you can discuss further with Mr. Travis, and you know, Mr. Travis, I'll leave that to you to work out either through motion or some kind of stipulation.
Mr. Ziegler and I have discussed for Ms. Weaver and for that, Your Honor, a stipulation once the restitution is paid.
Okay.
So we are discussing that.
Okay.
That's correct, yeah.
All right. Okay. Thank you. That's all for today, and the court's going to disconnect on this case. Chapman, are you able to hear me okay?
Yes.
Okay, we're on the record now in People versus Wyatt Chapman, case number 244957. The record should reflect that Mr. Chapman is appearing by Zoom today due to illness, although he is present here on the courthouse grounds. He's not coming into the courtroom due to his present illness. He's connected by Zoom. If I can have counsel with you.
I'll try to send me up, Mr. Chairman.
Okay, so we're still awaiting the evaluation, but it looks like Chapman has been cooperating with the process. Is that correct?
Yes, Your Honor, he's been interviewed. The doctor is basically collecting more records. He had, prior to this incident, spent some time with the local hospital, and she wanted those records, and she asked for some incident reports that the prosecutor's office got to me, and I forwarded to her. So the evaluation is, or the report is in process, but not completed.
Okay, Mr. Seeger, or I'm sorry, Mr. Ziegler.
Your Honor, I would just ask the court to adjourn it pending receipt of the report to the Center for Forensic Psychiatry.
Okay, I think that's really all we can do at this point. So the court will not schedule any further dates. Once that report is received, the court will schedule a hearing as required by statute, depending on the results of that report. Mr. Chapman, do you have any questions at all?
No, Your Honor.
Okay. Mr. Ziegler, anything further on this file today?
No, Your Honor.
Mr. Travis?
No, Your Honor, thank you.
Okay, Mr. Chapman, you're free to disconnect at this time.
Thank you.
Mr. Travis, do you have Mr. Willoughby or Mr. Hiddle?
Both. Right here, Your Honor.
People versus William Willoughby, case number 244988. Record should reflect Mr. Willoughby's present here in the courtroom today. Making him counsel put your appearances on in this file.
Brian Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Willoughby.
Okay, Mr. Travis, can you tell me the status of this file today?
Yes, Your Honor. It's my understanding we're going to be accepting a plea offer. My understanding of that offer is Mr. Willoughby would plead to a felonious assault. And that would be under HIDA, and that would dismiss all other counts.
Okay, and does that matter whether that's count 3 or 4?
Not to be, Your Honor.
Count 3, Your Honor.
Count 3. So pleading guilty to count 3 under HIDA, all other counts dismissed?
That's correct, Your Honor.
Okay. All right, Mr. Willoughby, let's see, how old are you?
I'm 18 years old.
18?
Yes, sir.
Okay. And have you discussed this plea agreement with Mr. Travis?
Yes, sir.
And is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Willoughby, are you on any kind of probation or parole?
No, sir.
And you understand that by pleading guilty to count 3, which is felonious assault or assault with a dangerous weapon, that that's a felony that carries with it a maximum possible penalty of up to 4 years and or a $2,000 fine.
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself if you want it. You understand all those rights?
Yes, sir.
Can you tell me what's going to happen to those rights by you pleading guilty?
They're going to be gone.
That's right. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you'd have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty of this crime?
Yes, sir.
So this happened back on November 6th of 2024. Is that the correct date?
Yes, sir.
Okay. And on that date, did you get into some type of altercation with David Hermstein here in Kalkaska County?
Yes, sir.
All right. And did you have a weapon at that time, a handgun, a pistol?
Yes, sir.
All right. And did you do something to make Mr. Hermstein fear that you were going to assault him or hurt him in some way?
Yes, sir.
Okay. And that involved the use of that pistol?
Yes, sir.
Mr. Ziegler, are the people satisfied with the factual basis?
Your Honor, just can I clarify one point for the court? Mr. Willoughby, that pistol was an air pistol, correct?
Yes, sir.
And it appeared to be a Glock.
Yes, sir.
You say a replica?
Yes, sir. It was a.
So it looked like a Glock, but it was in fact an air pistol.
Yes, sir.
And you either threatened Mr. Hermstein with that pistol or struck him with that pistol?
Yes, sir. I
Which one?
struck him.
You struck him with
Yes,
that
sir.
pistol?
Yes, sir.
I'm satisfied.
Mr. Travis?
That is accurate. Satisfied, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Willoughby, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Trevis so that you're prepared to go forward on that day. Before you leave today, you're going to meet with Agent Bear up here from the probation department to set up a pre-sentence interview, okay?
Yes, sir.
All right, thank you. People versus Timothy Hiddle, case number 244993 and 4994. The record should reflect Mr. Hiddle's present here in the courtroom today. If I can have counsel put your appearances on.
Ryan Ziegler, yeah, equally honor.
Kyle Travis, Mr. Hiddle.
Oh, sorry. And Mr. Travis, can you tell me the status of these two files today from the defense side?
Thank you, Your Honor. We did hold prelims on both files. I have been discussing plea bargains with my client and Mr. Ziegler. In discussing some matters relative to the case, Mr. Hiddle would like to go through the body cam, and discuss some matters with me and have me look into some things. So we would ask for 30 days to do that because even though I've seen it, Mr. Hiddle hasn't watched the body cam yet.
All right, so these are completely separate incidents, is that correct?
That is correct, Your Honor.
Correct.
So this wouldn't be a matter of consolidation?
No, Your
No,
Honor.
Your Honor.
Okay. All right. Mr. Ziegler, what's the people's position on the defense request?
Your Honor, it's the defendant's first appearance in circuit court. I don't have any objection to the attorney being requested at this reason.
Have there been any plea offers made?
Your Honor, I don't have one noted down, but I believe the offer that I had made was that the defendant could plead guilty to the possession of meth, or maybe even the possession of narcotics. And in exchange, the other counts would be dismissed. Mr. Travis and I have been in discussions about potential resolutions, but we haven't reached a solid offer yet.
Okay.
And Your Honor, one of the other issues that I don't know if we'll find an answer is Mr. Ziegler has indicated that Mr. Hiddle's got an Ohio paraphernalia conviction that we're really not sure of the status of. And that's why we were talking alternative offers, because we don't know if he truly qualifies for 7411 or not.
Okay.
That's fine.
So that's where it's another issue that we don't have an answer to at the moment.
Is 30 days going to be enough time to hash all of that out?
60 days. 60 days may give us more time because we may have to, I don't know if we'll have an answer to the 7411 issue because with the information we have from his criminal history, it's really not clear what's going on there. But it would be helpful to try and get some more info there.
I mean, I'd rather have us come back at a time where parties would be ready to either set up a trial or resolve it. So do you have any objection to a 60-day time frame?
I do not.
Mr. Ziegler? Okay, so we'll set it for a status conference plea hearing in 60 days. If we don't have a plea at that time, then the court will set it for trial. Both files. Anything further, Mr. Ziegler?
No, Your Honor.
Mr. Travis?
Nothing further, Your Honor.
Mr. Hiddle, do you have any questions?
No, Your Honor.
Thank you. Next hearing is set for 10:15. That's looks like the AG's office. I don't see them present yet, so we'll take a short recess and come back. Okay, counsel, can you put your appearance on the record, please?
Good morning, Your Honor. Carrie Angie on behalf of the Attorney General's office.
Okay, and can you just, can you spell that last name? I'm sorry, I didn't get your last name.
That's all right. It's A-N-G-E.
Can you pronounce that Angie?
That's correct.
Okay, great, thank you. All right, and we have Mr. Ross connected, so we'll go on the record. This is People versus Erin Ross, case number 244882. Counsel for the People's put her appearance on already, and Mr. Travis.
Kyle Travis on behalf of Mr. Ross, Your Honor.
The record should reflect Mr. Ross is appearing today by video. And what do we have up for today, Mr.
It was set for a 6-month review hearing, Your Honor.
Okay.
It was a child support case on a delay. We're basically at the halfway point.
Okay. Miss Angie, from the People's side of things, do you have any updates for the court?
I do, Your Honor. I see the defendant pled guilty as charged to 1 count under delayed sentence agreement on June 4th, 2024. I believe he was, the initial delayed sentence hearing was held on August 6th, at which time it was stated that if the defendant reduced his arrears to $11,500, my office would be happy to offer him an attempt. The arrears as of January 31st, just last Friday, I believe, were $11,431.86. So at this point, I would propose that we have two, or the defendant has a choice of one of two things. We can either enter the attempt and schedule the matter on for sentencing, or we can continue the delayed sentence for 5 more months and give him an opportunity, if he thinks he can do it, to pay down to 0, at which time we'd be happy to offer a disorderly person. Is that full and accurate, counsel?
That is my understanding, yes.
Okay, Mr. Travis, have you been able to speak with Mr. Ross about how he wants to proceed?
Your Honor, we didn't speak about the idea of entering a plea today. We just discussed the progress. I didn't necessarily think about that. So he hasn't had a chance to think about that, but I believe he wants to continue attempting to pay down the full balance to see if he can do it.
Okay.
Mr. Ross, is that correct? You would like to continue paying and see how far we can get by the end?
Yes.
Okay. All right, so what the court will do then, I'll set this for a hearing. 5 months would be July. I'm going to set it for a hearing at the beginning of August. And then let's see where we're at that point. Any objection to that, Miss Angie?
No, Your Honor. Thank you.
Okay, Mr. Travis.
No objection, Your Honor. Thank you.
Mr. Ross, do you have any questions?
No, sir. Everything sounds good.
Okay. All right. Thank you. That's all I have for this today. Then the court will send out notice of the date and time of that hearing in August. And Miss Angie, the state can appear by video as they've done throughout the case.
Thank you, Your Honor. That's very helpful. Thank you.
And Your Honor, could Mr. Ross appear by video again?
Yeah, I should have said that as well. Mr. Ross, also you can appear by video as well.
Okay. Thank you very much.
Okay. Thank you. You're both free to disconnect at this time.
Thank you.
Thank you.
Mr. Seeger, do you know if Miss Wheeler is present? Oh, she is. Are you ready on her case? Okay. Wheeler, if you can go right to that podium there, please. And we're on the record in People versus Kyy Wheeler. This is file number 244975. The record should reflect that Ms. Wheeler is present here in the courtroom today. I can have counsel put your appearances on.
Ryan's
This is the date and time set for a sentencing hearing in this case. Ms. Wheeler, have you had a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
Yeah, I've been trying to get a hold of him this week, though, and I couldn't get a hold of him.
Need some time to talk to him
If I
before?
could, please.
Sure, okay. Mr. Seeger, did you want to meet with her in the back?
That's fine. Your Honor.
Okay. All right, just let the court know when you're ready, Mr. Seeger. See, we'll take a short recess. Okay, we're back on the record. Ms. Wheeler, did you have an adequate opportunity to speak to Mr. Seeger?
Yes, sir.
Okay. Mr. Seeger, are there any additions, deletions, or corrections to the report?
No, Your Honor.
Are there any challenges to the scoring?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, this was a plea that contemplated 7411 and had some issues through the PSI process. But given the fact that she's 46 years of age and she only has one prior misdemeanor conviction, I do think she is still the kind of person that 7411 was designed for. It's clear that she has a substance abuse issue. I'm hopeful that a term of probation and some monitoring will help her correct those issues. So given her relative lack of any history, I still would support a sentence of 7411 probation, Your Honor. I think it's in everyone's best interest here.
Thank you, Mr. Seeger.
Your Honor, on behalf of Ms. Wheeler, I think she has had some step backs, and I think that at one point in time she was struggling with her addiction. I think the short amount of jail time that she spent has maybe allowed her to reevaluate some of the decisions that she was making previously. I have talked to her father, who's currently serious health problems. I think he had a heart attack. So she's struggling, and she wants to be with her father to try and make things right. Just recognizing that some of the choices that she's made has impacted the lives of other people. Maybe look at things in terms of what is most important. Which that would be that as it may, Your Honor, I'm somewhat at a crossroads with Ms. Wheeler. What I had told her was I'm concerned based on some of your prior distractions and maybe your ability to get rides, maybe your ability to do testing if that's required. That I'm not entirely convinced that you'll be able to successfully complete probation. On the other hand, because you have no prior criminal history per se, I want to give you that opportunity if that's what you want. But in the end, ultimately, if you're going to struggle on probation, I would rather you ask the court to conceivably close her file without the benefit of 7411, and that is the punishment in and of itself and is a learning lesson for her. At which point she can go out into the world and hopefully reach out for treatment if that's what she wishes to do. Or in the alternative, if the court sees fit to give her an opportunity to be on probation, to give her the benefit of 7411, which the prosecuting attorney is not specifically objecting to, and hopefully she will get to. So I guess I leave it to the court and the defendant to ask the court what it is that she specifically wants. I think in one hand, she wants to be released primarily because she wants to be with her family, which is reasonable. I think that she has learned from this situation. I'm just concerned that somebody who has the opportunity, they don't always do well, and it's not always because they have a relapse, it's for other reasons. And I guess from the onset, if she's released, either which way, I just want to give her the opportunity either to be released without being on paper, if that's what she chooses, knowing that she has a conviction, or in the alternative, to give her the opportunity to be on 7411 probation, at which point she'll have to successfully complete her probation in order to receive that remedy. She had indicated that she wishes to be on probation. She also had indicated that compliance and the case was closed and the felony entered onto a record that would also be agreeable. So I guess we'll just leave to Ms. Wheeler what she thinks is most prudent, but that's my viewpoint of the case.
Thank you. Ms. Wheeler, anything you wanted to say?
Everything Mr. Seeger said's right. I kind of think and reevaluate my situation. You know, I feel some really reckless and irresponsible things that is affecting the family quite badly. I'm trying to correct them. I signed up to get the shot at the jail to help me if I get out. I'm gonna go to a rehab when I get out. My dad asked me to go to one also. I'm just waiting to find out what happens with me before I can figure that part of it out.
All right, well, I read through the report, so I'm familiar with your circumstances, your background. I'm also familiar with what happened in this case, bring it before the court here today. And you know, it's my view, number one, you've been on probation one other time that didn't go well, but certainly, that in and of itself isn't a reason to order probation in this case. I think probation is appropriate. I think you need some help and some supervision and some oversight to do the things like get some treatment, and you need some help finding those resources. And I think probation can benefit you in that way. I don't think rehabilitation at this point, although your criminal history isn't lengthy, certainly your history of problems with substances is lengthy. But I don't think rehabilitation is something that the court can say is off the table at this point, given your record. So I think it's appropriate to give you another opportunity through probation to do that. And you do qualify for 7411, so I think it's appropriate to give you that opportunity as well. So the court is going to place you on probation pursuant to 7411 for a period of 18 months. The court is going to adopt as the conditions of your probation all the standard terms and conditions, which of course, number one is that you not use or possess any controlled substances unless they're prescribed to you, and that you comply with and successfully complete any type of treatment program that's recommended to you by your probation agent.
Okay.
The court is going to impose 6 months in the Kalkaska County Jail with credit for 31 days served. The court's going to hold that balance in abeyance. So you're going to be released right away. If you violate your probation, though, the court can impose any or all of that remaining time immediately, regardless of what happens with the probation violation. So there's a significant negative here if you don't comply in terms of jail time.
Okay.
The court is going to order that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost, along with a supervision fee of $30 per month while you're on probation. Because this sentence is going to be pursuant to 7411, there are no appellate rights at this time. But before Mr. Agent Barrett, will you meet with her before she's released?
I will.
Okay, so you're going to meet with Agent Barrett before you're released to go over your probation. Okay. Mr. Ziegler, anything further today on this file?
No, Your Honor.
Mr. Seeger?
No, sir.
Good luck to you going forward, Mr. Willoughby. Okay, next hearing set for 10:45. That's going to be by video, so we'll be in recess until that time. right, Mr. Davis, are you able to hear me okay?
I am, thank you.
Okay. We're on the record now in People versus Matthews. This is file number 244978. The record should reflect Mr. Matthews is present today by Zoom video along with his counsel, Mr. Davis. Mr. Ziegler is present here in the courtroom today. This is set for a status conference in this file. Mr. Davis, can you tell me the status of this case from the defense side?
Yes, Your Honor, we're prepared to offer a plea to the offer in this case.
Okay, and can you tell me what your understanding is of the plea agreement?
My understanding is that the defendant will be pleading to count 1. In exchange for that, count 2 would be dismissed, and that and there is no sentence agreement or COPS evaluation in this case.
Okay, Mr. Ziegler?
That's correct, Your Honor. We would also agree not to charge Mr. Matthews for any other potential charges arising out of the same incident.
Okay, all right, thank you. Mr. Matthews, can you unmute, please?
Yes, sir.
All right, thank you. Mr. Matthews, were you able to hear all of that?
Yes, sir.
Is that the plea agreement that you've discussed with your attorney, Mr. Davis?
Yes.
Is that how you want to proceed today?
Yes, sir.
Can you raise your right hand, please? There you go. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Matthews, are you currently on any kind of probation or parole?
No, sir.
All right. And you understand that by pleading guilty to count 1, which is possession with the intent to deliver methamphetamine, that's a felony that carries with it a maximum possible penalty of up to 20 years and or a $25,000 fine?
Yes, sir.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
So right now you have certain rights. I'm going to go through those with you here on the record today. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
Can you tell me what will happen to those rights by you pleading guilty today?
They will, I won't have those rights.
That's correct. You'd be waiving them and giving them up, and you won't have them anymore, and that includes the right to have a trial. Do you understand that?
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised anything other than what we've said here in court today?
Excuse me, can you repeat that? It went out.
Sure. Has anybody promised you anything other than what we've said in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
Okay, the information I have indicates that this happened back on July 9th of 2024. Is that the correct day?
Yes, sir.
On that day, were you present here in Kalkaska County?
Yes, sir.
Did you have possession of some methamphetamine at that time?
Yes, sir.
And was it your intent to either give or sell that methamphetamine to another person?
Yes, sir.
Did you have any legal right to do that at that time?
No, sir.
All right, Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Davis, are you satisfied with the factual basis?
Satisfied, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Davis, are you?
Aware of none?
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Davis, are you?
Yes, Your Honor.
All right, thank you. The court finds, Mr. Matthews, that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing, as well, Mr. Davis, your attorney. It's important that you stay in touch with him prior to that date. Ms. Agent Barrett, how do you want to make contact?
Yeah, it'd be okay if I get his phone number and his address, just.
So I'm gonna have them, I don't want to put that out on the, can they contact you?
Yeah.
Can you, Mr. Davis, can you take down a phone number for your client?
Yes.
989-598-5760.
I have 989-598-5760.
Correct.
Okay, that's for the probation department, I'm assuming?
Yes, and just have
Okay.
him call me at 1 o'clock today.
Okay, will do. Thank you so much.
Thank you.
Okay, so Mr. Matthews, make sure that you talk to Mr. Davis and that you make that call by 1 o'clock today, or at 1 o'clock today, okay?
Okay.
And then the sentencing hearing will be in person here in Kalkaska. So Mr. Davis, I will need you and Mr. Matthews to be here for the sentencing hearing, okay?
Of course, thank you, Your Honor. And I also would like to thank you and your staff for your flexibility today. My schedule, I messed up. So I appreciate you all being flexible.
Well, and I forgot that you had requested that at the last hearing, so no problem. And I'm glad we were able to get this hearing done today. You and Mr. Matthews are free to disconnect.
Okay, thank you. Have a great day. Bye.
All right. Mr. Seeger, is Mr. Horowitz out in the hallway? Are you ready with one of your cases?
I have Ms. Smith.
Okay. We're ahead, but I can take that file now if you want. People versus Chelsea, Erin Smith. Miss, if you can just come right up to the podium there, please. This is file number 244997. The record should reflect that Ms. Smith is present here in the courtroom today. If I could have counsel put your appearances on.
Thomas Cedar, Smith.
This is set for status conference here today. Mr. Seeger, can you tell me where things are at from the defense side?
Your Honor, it's my understanding that Ms. Smith is going to tender a plea to 1 count of possession of narcotics in exchange with a count together with enhancement.
So, a 4-year.
Correct.
And are we taking the plea to the factual basis of count 1?
Yes, Your Honor.
Ms. Smith, have you had a chance to talk to Mr. Seeger about this plea agreement?
Yes, I have.
Okay, and what we've just said here, which is that you're going to plead to a possession of narcotics charge as opposed to the possession of methamphetamine, is that the agreement?
Yes.
Okay. Is that how you wanted to proceed?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Are you currently on any kind of probation or parole?
I'm not.
And as we've indicated here, you understand that the maximum possible penalty that you could face for possession of narcotics is up to 4 years?
Correct.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself if you wanted. Do you understand all those rights?
Yes, sir.
And can you tell me what would happen to those rights by you pleading guilty?
They'll be waived.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that? Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here today in court?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes.
This happened back on June 18th of 2024, is that correct?
Yes.
On that date, were you present here in Kalkaska County?
Yes, I will.
And at that time, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time? Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger? Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in taking of this plea? Okay. Ms. Erin Smith, the court finds that your plea is knowing, voluntary, and accurate. Court is satisfied there's a factual basis to support a finding that you are guilty of this added count 2 of possession of narcotics. The court will accept your guilty plea. You're going to meet with Agent Barrett before you leave here today to set up a pre-sentence interview. The court is going to set this for a sentencing hearing. You'll be notified of the date and time of that hearing by mail. It's important that you stay in touch with Mr. Seeger prior to that date, okay? Okay. Mr. Ziegler, do you have the tax code? You can just ask him.
Oh, okay.
Instead of
Ryan,
asking
can I
me
get
to
the
ask.
tax? 333.
7403 2 A's and Adam 5.
All right, great, thank you.
I definitely don't. Evans, you want to come forward up to the podium?
Just Mr. Horowitz was next door.
Is he in the other courtroom?
Yeah, I think he was just finishing.
Oh, yes. Okay. All right.
Yep.
You need a minute, Mr.
No.
Okay.
Yes.
We're on the record in People versus Evans, file number 234811. The record should reflect Mr. Evans is present here in the courtroom today. If I could have counsel put your appearance on.
Ryan Ziegler on behalf of people.
Judge Michael Horowitz on behalf of Mr. Evans.
I believe we set this as a status conference today. There's a, do you know what the status of the appeal is?
Yeah, so leave for interlocutory was granted. The briefing on the interlocutory has been completed. The court has not yet announced a panel or scheduled an argument. I don't know what we can expect the time frame to be at this point. I think it probably makes sense to have another status hearing in a couple months and see if we've got any updates from the court.
Mr. Ziegler?
Your Honor, that's all accurate as far as I'm aware. I don't have any objection to the adjournment being requested. Hopefully we can get a date.
Okay. I'm going to set this quite a ways out. Obviously, we'll all be notified, including myself, once there's a decision. So if it happens before, then I can set the hearing right away. But I'm going to set this out at 6 months for a status conference. I'm sure we'll have it before then, but I don't want to keep making you, Mr. Evans, and counsel come in here for no reason if we don't have a decision. I am anticipating we will prior to that time, and when it comes in, then the court will set it for its next available date. Any objection to that, Mr. Horowitz?
No, Your Honor. Thank you.
Mr. Ziegler?
No, Your Honor.
Mr. Evans, did you have any questions?
Sir.
Okay, thank you. That's all for today. Next file for 11 a.m. is People versus English, case number 244923, 4925. I don't see them connected yet.
Judge Ziegler? I'm sorry to cut you off.
That's all right, go ahead.
There were some emails circulated that Mr. English would not be present because he's been transported from the Central Michigan Correctional that he's housed at to Muskegon, and he's in transit today.
Okay.
So I'm not sure where I got the emails from, but I saw that today. It might have been in response to people's read.
Okay. Mr. Ziegler?
We were notified of that this morning, Your Honor. They were going to be transporting Muskegon today. He was not going to be available. Obviously, we didn't have time to fix that. So I would just set it out for its next motion date. Hopefully we'll be able to do it.
Any objection?
No, Judge. I would ask if the court received a stipulation.
Was it a modification to bond to allow contact?
Yes.
I believe I did, and I believe I did sign that.
Okay, thank you. That's Mr. English's greatest concern. We'll be pleased to hear that. Thank you.
Yeah. Okay. All right, so the court will set this for another hearing. Obviously, Mr. Ziegler, the court will just request that your office prepare a writ for Mr. English's appearance by Zoom. Anything else that we can address on this file today, Mr. Horowitz?
No, thank you.
Great. Next hearing set for 11:45. We'll be in recess until that time.
All right.
Here, yeah.
I was up at 2:30 with the brief last night.
Oh. The reply brief?
No.
Oh,
Or I
that's
was
good
different.
time.
I got it in before. I got it in before midnight last time. It was 3:30.
Did you ever file a reply brief on Mr. Evans?
I did.
Okay,
I should have got notified on my file.
it probably got caught in my spam filter.
I could just forward it to you.
That would be great.
Yeah, anyway. And I did, man, when I was on vacation last May when we were in Greece.
Yeah.
I had an Alaska hearing.
Oh, God.
I was sitting on a deck at like 3 a.m. in the morning. It was dark. It was like overlooking the Mediterranean, and like the noises were so crazy.
Yeah.
Like I would have never otherwise been up, you know, and like how many feral cats there are, and it's like crazy. But I'm a little slap happy right now, to be honest.
Yeah,
I
go
got
get some sleep.
well, gonna try to get rid of some of these Monster energy drinks.
I think I got adjourned. May got taken off, Johnson got adjourned to March 4th. Lancer got adjourned to March 4th. I already did Aaron's, so the last thing that was.
I'd say relax. Well, I did that. One, because it was newer, right? And the recency of citation is important, but also because
Oh, sure. Just.
My rationale. Probably. The reason why. I'm telling you that the line. It's very close. Do I have a question? The reason why. For the. I think that. That box of that. Lectures I've been at, lecture panels of the course of the field, are giving talks. They have suggested that when they grant leave, based on leave application, if they, if they're interested. And if they're interested in it, if they want to talk to you. So I'm gonna give them. Class. So anytime somebody pleads, so I'm on this list, these cases. Be like. One. Any case, somebody gets or they just fill out paperwork, or they're like, hey. They ask me. Three courses.
Basically, once you have your trial.
Oh, I did try. That time. I actually have a case. They want, we're here once because it's a cheap. Concerns. They don't because of the way. Yeah, I don't. No. I don't think it's. But it just looks like Was it played at that? I usually lessons. And what you expect. But I do have. Deal. Yeah. I'll answer about if my can come back to that.
Yeah, you know, primarily because he's got the keys and
That too. Generally. No, if you just. Sure, they could. They always. But. Yeah. Michael K. And
Yeah, some of them. Well, never shot. One that's one that. That one though. Yeah. Both these are all trials. One that one. Lost. There. Yeah. It's good. It's going, but. Yeah, that's why you gotta be careful, not have shit on your phone, and not mess around with girls from dating sites, not talk to police, and all that shit. That shit's already passed. I know to that, stay away from the conditions. I don't know. No, no, it's different. Yeah, you can see him in the child. People just send shit. No, I know. But my point would be. No, my point is this. Not let me finish the bucket, but this is also. Here's the ball. Here's the big one. Okay. This is now this. Yeah, I don't know. Well, I don't think that. No, it's because it was like a. It's because. Yeah, that's all it was. It was, something blinking at the bottom of the website. Or like a thumbnail of a video, taking it down. I don't care. I don't know. I'm telling you different. No, I get your point. Right. Say it. And then keep on. No, I look at it. Obviously, you can tell by the small. Yeah, I do. If it's 19, that's normal. If you're not normal, you're anyway. So you have to get that.
Yeah, I'm that embarrassed.
That's
Well, it is, but that's.
like if you go to porn site, there's a thumbnail picture. It might just be in there. It's just a thumbnail. Now it's in your cache. I got it. Fortunately. Oh, I was gonna go. Hey, dude. It proves it. A little slow. Oh, there you go. Right. I just follow my travel camera. Way worse than this year. They're like.
Oh, I think she may be out in the lobby. I heard talking to her.
Okay,
Want me to
yeah, if
see
she's
if
here, we
can-
can.
Anyone there?
Christie,
Yes.
and we just need Vera too.
Oh, okay.
It does. No, that's you're absolutely correct.
Yeah, no kidding. We'll take it.
It's a probation check. Yeah. Just leave it. Yeah, I don't have anything there. the same. So you probably can't.
Okay.
It was pretty.
Yeah.
Yeah.
No,
Yeah. So the guy was working at some gas station or something. Scratch off. Yep, and if it was fine. Oh, that's it. Yeah. Get there every time. Try to keep on. It kind of ruins the fun.
It does.
You know, like you just, I gotta attack it.
So yeah.
See you, Mike.
Have a great day.
You too.
Mike, yeah. Oh, crap.
Yeah.
That's not a bad idea. He'll be all calm and collected and walking the door. I'm just gonna tell him it's not a win solution.
That's gonna take us.
I don't know where we're going from there.
Chris, do you have a warrant? Just like.
So the original one, it looks like Shannon amended it because the original one was for the report and then she amended it. And I don't know if you've seen that.
I can't admit to this, but I mean, I can at least admit to. Okay, well, I mean. Okay, we can do that.
I mean, it's whatever you want to do. I mean.
I'm willing to do whatever.
Shannon did
All right,
and I said it.
okay, that makes sense.
So
I can try and.
this has been submitted, so I'm guessing. That will not be my. No, well, it's freedom of information violation, so. Okay, fair enough.
It's up to you.
If we were just gonna dismiss the.
Yeah.
There's no point in splitting it up.
No.
You betcha. So either which way, you probably want to answer. That's up to you. If you want one, you need to vote this form.
All rise. Court has been reconvened.
Thank you. Ms. Hallwick, you can come right up to the front there, please.